good day, whoever from different parts of the world. I have an honor and a privilege to be the moderator of today's discussion. My name is Saba Pipia, for those who don't know me. I am an associate professor at Georgian-American University, but currently I'm a visiting researcher at the Michigan State University. And today we have the last meeting, last webinar of our Migration Talks series, together with the ICMPD in Georgia. I will make a brief introduction of the speakers, and then we will have some time to speak about the importance of today's event, and then we go into details and we'll have a presentations, and then we will also have a possibility for the discussions. Again, I would like to once again tell you that the participants are not visible here, but during the discussions stage, you will have an option to raise your hand, and I will promote you as a co-host, so you will be visible and you can ask the question, or it's always an option to put the questions in the chat if you don't want to speak when we will have a discussion, and I will read out the question to the panelists. So today we have a very, very outstanding and distinguished speakers, and I am very happy that I personally had the opportunity to work with both of them. Professor Anne Peters is a director at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and a professor at the Universities of Heidelberg, Free University of Berlin, Basel, and University of Michigan. She was the president of the European Society of International Law, a substitute member of the Venice Commission, and a legal expert for the Independent International Fact-Finding Mission on the Conflict in Georgia, so-called Taliavini Commission. Her research and teaching areas relate to various branches of public international law. She is author of many publications in the field of international law, and is one of the prominent, let's say, contemporary international law scholar. It's a very, very brief introduction of her work, so please forgive me, Professor Peters, that I did not go into details, but we value your time and your dedication to come and join us. And we also, as format of the Migration Talks implies, we have also co-speaker from our side. And we have a also very outstanding and distinguished speaker, Professor Ketevan Khutsishvili, who is a professor at Tbilisi State University with almost 20 years of teaching and research experience. She obtained her master's degree from the London School of Economics and subsequently got her PhD from Tbilisi State University. She was the initiator of introduction of many learning courses in international law curricula in Georgia, such as international criminal law, international migration and trafficking, gender and law. She is founder of Levan Alexidze Foundation and the director of International Teaching and Research Center for International Criminal Law and International Cooperation in Criminal Matters. And also this Migration Talks series is carried out by her initiative in cooperation with the ICMPD. So also very brief introduction of you, Professor Khutsishvili. So forgive me both for this. I am really flattered and thrilled to be to have an honor to be a moderator today. And as you all know, or for those who don't know, Georgia celebrates International Law Day for already second year, every 5th of July, which coincides the birthday of the founder of International Law School in Georgia, Professor Levan Alexidze, and the Levan Alexidze Foundation is also one of the main initiator of today's event. So that's why before going into presentation and the substantial part of the presentation, I would like to kindly ask Professor Khutsishvili to briefly make an introductory remarks about the importance of today's event. Professor Khutsishvili, you have the floor. Please.
Thank you, Saba. And again, my appreciation goes to Professor Peters, who could find time and join us today, which is for the country we are in, Georgia, quite a remarkable day, as today we celebrate International Law Day, and we pay with that tribute to, as Saba mentioned, Professor Levan Alexidze, who was full member of the Georgian National Academy of Sciences and who established International Law School in Georgia. Apart from being the co-author of the declaration of restoration of statehood, the independent statehood of Georgia. He also, of course, contributed to the provisions of constitution, which actually make international law legally binding for Georgia, and also recognizing the supremacy of international law over the domestic legislation in this country. Henceforth, his birthday after his passing away was also nominated or declared as International Law Day. And today there are a lot of celebratory events, including the launch of the Levan Alexidze International Law Academy, for which there will be a range of events and classes with distinguished speakers for quite good group of young professionals who are interested in different directions of international law. And that is how and why this event held today is even more important than the content would be in any case, particularly again for the country where the topic of today's discussion is so much relevant and important. But the day itself gives it even bigger value and importance. So I again appreciate time and interest of everyone. Value very much the support by Professor Peters, and I stop here for the moment.
Thank you so much, Professor Khutsishvili. So I would like to congratulate everyone today's day, those who celebrate as an International Law Day, and I'm happy that we had this event on the occasion of International Law Day in Georgia. So today we are speaking about the passportization practices, which is a very tough issue in Georgia and in Ukraine in particular, because this is the policies and practices pushed by Russian Federation in the breakaway regions. So we will be speaking about this policy and its linkage to the freedom of movement in the breakaway regions as well. And we are using the opportunity of having Professor Peters here, who worked in, as I mentioned, in the Tagliavini Commission, and hence on behalf of all Georgia academia and everyone who is using this document, I would like to once again express my gratitude towards the hard work you and your colleagues did in this unprecedented, I would say, occasion to having this very large document prepared, because in every courts or tribunals decision or the books wherever on international level, whenever there is a reference to the conflict in Georgia, we always see that this document is used and applied as a source of information. So once again, thank you for that. And there is one part about passportization as well in that document. So for the beginning of our conversation today, I would firstly I would like to ask the question to Professor Peters. Could you please outline the framework of legality of large-scale extraterritorial naturalization practices, which is also referred as a passportization, as I mentioned? And in this regard, could you please focus in which circumstances, if any, such practices may be considered as legal under international law, or collective passportization abroad would always be qualified as unlawful? And if it's unlawful, then what principles of international law may allegedly be violated with such a large-scale passportization without consent of the territorial state, in this regard, Georgia and Ukraine? Professor Peters, you have the floor, please.
Yeah, thank you very much, Saba. Thank you very much, Professor Khutsishvili. Of course, it's my pleasure to participate in the seminar, and I find it wonderful that there exists an International Law Day in Georgia. I think such a day should exist, of course, everywhere, but I don't think there is one in Germany or Switzerland, my home countries. For me, it is a wonderful occasion to discuss again this topic, in which I caught interest when working for the fact-finding mission for the Tagliavini mission, and it was completely neglected and under-researched issue in international law before the Commission looked at that. And I'm also particularly pleased to be hosted here by Saba, who has been a visiting scholar also at the Max Planck Institute in Heidelberg last year, or maybe already 2 years ago. Time is flying. In pre-pandemic times. Yes, so first of all, the question is, what do we mean by passportization? This term has been established, although, of course, the passport as such is not the nationality. It is a document which can prove nationality, but it is a rebuttable presumption. So it's only a document. But the word passportization has been established to describe policies which are the conferral of nationality, for example, Russian nationality, as a second, this is called the secondary acquisition of nationality of a person who is already born and has already got another nationality by birth. So we're speaking of the acquisition or conferral of a second nationality, and it has been done in Russian practice always by administrative acts upon the application of a person, maybe with some coercion. We will come on to that. So it is not, the policy which Russia has pursued is not an automatic distribution of this nationality by law. This is something else. For example, in Crimea, when a territory switches side and when the border is redrawn, as in the case of Crimea, that suddenly the peninsula became Russia, there was a Russian law which said that automatically all inhabitants will become Russian citizens. They had a period of 1 month to opt out of the Russian nationality. So this was a conferral by law. But here, speaking of passportization means it is individualized, although it is done on a large scale and in a simplified procedure, it is still on a case-by-case basis and not automatically by law. And the key point is it is extraterritorial, and that is the nationality is conferred on people who do not live inside Russia. So these are the three elements of the so-called passportization policies. And now Saba asked the question, is it unlawful under international law? And the first point is that the naturalization, the conferral of nationality on people outside the state's territory is not per se unlawful. It is done very often. It can be done. So it would only be lawful if it came about automatically by law. If Russia established a law saying all inhabitants of Donbass are ex lege by law Russians, then that would be unlawful, but not the individual extraterritorial conferral of the nationality. If it's on request and on an individual basis, then such conferral of nationality is allowed when there is a certain factual link to Russia. So there must be some link, factual ties. There is, and some of you might know that in international law, the term genuine link, which was used by the International Court of Justice in the Nottebohm judgment. And the word genuine link is also used, for example, in the European Convention on Nationality. But it's not exactly clear what does genuine mean. And I would say that the factual link need not be so tight as it was required in Nottebohm, which was for the purposes of the state of Guatemala the state of Liechtenstein, sorry, to exercise diplomatic protection for Nottebohm. So that was a special case. But in any case, some factual link is needed. That could be, for example, a family link to Russia or a prior residence in Russia or current business relationships to Russia. I would say that the mere fact that a person had a former Soviet nationality is not a sufficient factual link. So it's not quite, there is some margin of appreciation here, of course. So if there is some link, then such passportization is not illegal under international law. However, I think, and that was also what the Tagliavini Commission argued, but that in the extreme case, the passportization policies can amount to an abuse of rights. Abuse of rights is present when a state exercises its competences, for example, the sovereign right to give the nationality to people. But when this is done in an abusive way, here we have to look at the context and at the motives of the Russian Federation. In the case of Ukraine, it is pretty obvious, I would say, that the purpose is to destabilize the region and to prolongate the conflict. And there is, in a way, a vicious circle, because the more destabilized the region is, the more afraid people get and the more they seek Russian passports and Russian nationality, because they think that then they will be easy, they can more easily migrate to Russia. So it is a vicious circle. The passportization destabilizes, and the more unstable the region is, the more people will ask for the passport. Russia also, and I think this was clearly the case in Georgia, sought to expand its geopolitically expand its sphere of influence. In Georgia, in Abkhazia and South Ossetia, the policy was also intensified, specifically during the period of tension and war. And I think another motive now with regard to Ukraine is a demographic motive, that Russia needs a labor force and needs population, and therefore wants to attract labor force. And another aspect which was present in the Georgian war was that Russia used the fact that there were Russian citizens in South Ossetia and Abkhazia as a pretext for intervening, and said, we are now conducting an intervention to protect our nationals, which they had themselves created before. But it doesn't look like this now in Ukraine. So the passportization is not unlawful per se, but might, in certain contexts, amount to an abuse of rights. And the Council of Europe has already concluded with regard to Ukraine in Council conclusions of June 2019 that it expresses, I quote the Council conclusions, expresses its utmost concern about the Russian presidential decree which allowed the simplified issuing of passports, and said that this runs counter to the spirit and objectives of the Minsk agreements. The Minsk agreements are not international hard law. In any case, they are not ordinary international law treaties, but have a controversial legal status. And the EU says this runs counter to the spirits and objectives. So now I spoke a lot, but I still haven't answered your second question concerning the principles which govern the whole thing. I don't know. Do you want me to continue still on the basic principles?
Yes, like in case we assume that the passportization was illegal, then what about this public international, general international law principles too, which could be allegedly violated?
Okay. I think, I mean, the first point to make is that the law of nationality and citizenship there are two levels. First of all, the decisions about who becomes a national of a state is, of course, in the domaine réservé and is of utmost an internal affair of a state. And for internal purposes, the word citizenship is maybe even more often used than nationality when we speak in everyday language. We speak of citizenship. But on the international plane, the word nationality is more often used. And we can roughly say that although it is an expression of a state's sovereignty to confer its nationality on people, this is limited by international law. So there are international law limits, but these limits of international law, they can of course also change and they can evolve. The limits can flow from customary law and they can flow from treaty law. However, the treaty law on nationality is also quite complicated and messy. There are bilateral treaties, but there are also some important multilateral treaties. And I already mentioned one multilateral treaty, that is the European Convention on Nationality of 1997. This was elaborated within the Council of Europe, but Georgia is no party to this European Convention, but Ukraine is, and Russia has not ratified either. And I think that there is also one principle in the international law on nationality which has emerged recently, the principle to avoid statelessness. That is a certain objective of international law. We also have to take into account that nowadays human rights are, of course, the starting point of all reflection. And so the first question is there a human right to a nationality? You know, of course, the famous dictum by Hannah Arendt about the right to have rights. And by that, she meant a right to a nationality, because she realized, and that was, of course, the practice of all totalitarian regimes, to strip people of their nationality, to make them rightless. So nationality is important to receive protection. And in the Universal Declaration of Human Rights, there is one article, Article 15, which says everyone has a right to nationality. However, as you know, this Universal Declaration is no hard treaty. It is a resolution of the General Assembly. So we don't know exactly, I don't know exactly what is the possible customary law statutes of this provision of Article 15. And the International Covenant on Political and Civil Rights and the European Convention on Human Rights, they have no article on a human right to nationality. And that was on purpose, because it is often said that a human right to nationality doesn't make sense because the addressee is unknown. If a person says, okay, I am entitled to a nationality and nobody wants to give it, so what? So that's the controversy here. However, Article 15 of the Universal Declaration mentions not only the right to get a nationality, but also the right to change the nationality and the right to keep the nationality. So with regard to passportization, what's at issue is the right to change the nationality, because people living in Ukraine or in Abkhazia and South Ossetia, they apply for Russian citizenship. So they want to change, or they want an additional in any case. And there is the provision in the Universal Declaration of Human Rights which says no one shall be arbitrarily deprived of his nationality nor denied the right to change. And now we have a question of interpretation. Does it mean that nobody may never be denied the right to change? Or is it rather that the word arbitrary must also be read into it? And I think the sentence says, can be read as, no one shall be arbitrarily denied the right to change. Okay, so we have the right to change the nationality, but no human right is absolute. That would be also my argument. There is, with all human rights, there is the possibility of curtailing the right if there are overriding public interests. So we have to look for a public interest, for example, for Ukraine, to say, no, we are not going to release you from our citizenship. And although, of course, the nationals of a state are no longer seen as a chattel of the state, like belonging to the state, still the nation is an element of statehood. If there is a state with no citizens left, then it's no longer a state. So the state has some interest in keeping its nationals. And therefore, I would say that Ukraine or Georgia may refuse to release the people from its nationality if this is not arbitrary. And I would say, and the European Convention of 1997 also says that, it is not arbitrary if a state says you can leave my nationality, but only if you also move abroad. So if you stay inside, then I want you to keep the citizenship. And I must say, I don't know the current policies of Ukraine and Georgia. I think that they do try to keep the people, even if they also acquire the Russian citizenship. And that is allowed. So the people have the human right to get the other citizenship, but they don't have the right to get released from Ukraine and Georgia. So I think that would be the main parameters, I think.
Yes, I think Professor Khutsishvili will also speak about this Georgia's policy, how to keep those people. But before turning to her, maybe like briefly also one more question to you regarding the consensual nature of this passportization. We know that not so many facts are available, but maybe like generally speaking, because you already mentioned that people usually take those passports because this is their gateway to go to Russia, and like pensions or I don't know, so the other benefits. So we speak about the like a kind of like forcibility in this, even though it's like by application or by law or by something. So can we speak that they don't have any other option left, and how this would affect the legality of these kind of actions? Briefly, not like because we know not so many.
So as I said, nowadays the human right is the starting point, and the will of the humans is the starting point, and that means that it is prohibited to impose the nationality on someone, except in the special situation, as I said, Crimea, when there is a change of the boundary. The current international law still allows that Russia imposes the nationality, and the delay for people to opt out was quite short, only 1 month. But this is probably not illegal. Now, coming back to South Ossetia and Abkhazia and now the Donbas region, in the Tagliavini report, no definite findings could be made about the forceful nature. Georgia had always argued that Russia had threatened expulsions or punitive taxes, but the commission could not confirm those facts. The Tagliavini report wrote that it can be assumed that in Georgia before August 2018, so before outbreak of the war, it was generally on a voluntary basis. And Saba, you already mentioned, people want benefits, for example, social security, they want pensions, and such incentives are allowed. It is allowed that a state gives incentives. It's also the other way around. You know, the golden passports that a state makes money on by asking people to pay a lot of money to get the nationality. So you could say the flip side is also that the state can make itself very attractive. Of course, I think we have to take into account the overall context of unlawful use of military force. And with regard, coming back to Crimea again, the referendum in Crimea was not recognized as legal. It was not recognized that the population expressed its free will because it was under military pressure. So if we compare it to that situation, one might argue if there is the overall military context, people are intimidated and are afraid, and that they cannot exercise their free will. I think that is a possible argument, but it is not, there is no precedent or there is no official judgment recognizing such an argument. Another matter would be ethnic or racial discrimination. If the passport would be given selectively on ethnic basis, that would be discriminatory, and that would also be clearly lawful.
Thank you, Professor Peters. And now we would turn to Professor Khutsishvili. We know that the conflict in eastern Ukraine is still ongoing, and we know that also the military occupation in Georgia's regions are still ongoing. So can we speak about the kind of linkage between international humanitarian law and this passportization policy and practices in those breakaway regions? In particular, could we say that this large-scale naturalization campaign might be qualified as an attempt by Russia to forcibly change the demographic composition of its territories, or to de facto annex the territories? Basically, those are the allegations by Georgia and Ukraine when they are speaking about this policy and practice in Georgia. So can we somehow like link those like passportization practices and the IHL obligations? Is it possible, especially in light that the conflicts are still ongoing in Ukraine?
Well, if we look at this question in the prism of what Professor Peters just outlined, that the passportization per se does not mean that it's always illegal, but then you have criteria to follow to understand what are we talking about. Of course, here we have state interests. We have, as it was already mentioned, rights and interests of individuals. And then in the light of the question just posed to me, of course, we have the element of international humanitarian law entering. And if we consider the case of Ukraine, you're of course absolutely right to distinguish between the two cases. Eastern Ukraine with still ongoing armed activities, and Crimea, which, as we know, already in 2014 was illegally annexed by Russia. Then Ukraine's Autonomous Republic of Crimea and the city of Sevastopol were put under distinct regime as a result of Russian intervention, and the passportization efforts in Crimea, therefore, were predicated on Russia taking full responsibility for the administration of the territory. It is true the administration of the territory is illegal, but still it's under the Russian, or it was the Russian administration was established. So with that, I think it was also mentioned that there was a Russian law, a Russian federal law in March of the same year, which basically put forward the way for the passportization of Crimea. And then the story developed of collective naturalization. Now, we distinguish, of course, this case from the Eastern Ukraine, where the armed activities are still ongoing. However, they are also under temporary occupation, as we see the statements from different authoritative international organizations, but of course also from the authorities in Ukraine. Now, to link this entire story to the rules governing international humanitarian law, we witnessed, at least by the end of 2020, the Russian officials were announcing on the intention to issue up to 800 passports in the temporary occupied areas of Donetsk and Luhansk regions of Ukraine. There are different figures which give us different information on how many passports are issued, but the statements, official statements from the Russian officials are coming. Now, why does Russia need this? What is the angle? The demography was mentioned, and I agree totally. Demography is something that we witness already, or Russia witnessed already, that they have sliding population figures, and that was actually predicted already around 25 years ago. I still remember discussions by the Russian scientists that they were predicting this, and 25 years ago, what I remember, they were predicting that in 50 years Russia will be in dire need of human capital. So I don't know, we are halfway. Maybe this is what we are witnessing now. But apart from that, we witness what? We witness the statements of the Russian administration on the participation of residents of the occupied territories of both Donetsk and Luhansk regions, who have illegally issued Russian passports, illegally because of I mentioned this and underlined in the prism of our discussion here, to participate in the Russian constitutional referendum. Now, there is another line of evidence which prove that Kremlin continues to basically hamper the opportunities for reintegration of the temporarily occupied parts of Ukraine. And as Professor Peters mentioned, strengthening the social or other, economic, maybe legal links with the Russian Federation, even though I agree that we don't really know what the genuine link means, but there is certain meaning, and then with the practice, probably Russia is also trying to establish some sort of genuinity of this link of residents of these territories of Ukraine with the Russian Federation. Now, when we look at the rules, as the question is about international humanitarian law, what do we learn from the rules? Humanitarian law prohibits what? Of course, it prohibits the acquisition of sovereignty over the territory that is occupied. And here I use occupation on purpose because, again, even though I recognize fully and agree that Crimea is different from Luhansk and Donetsk, it's still under temporary occupation. In my conviction, and as per international law, occupation shall be temporary, but unfortunately, Russia doesn't seem to know that this word exists. So therefore, I stress the temporary occupation, again, the same language that's used, including by the United Nations and the European Union when referring to these territories. And then IHL also tells us that population transfers cannot happen, right? And this refers to collective. And again, if we look at the processes of passportization, we have collective passportization. So one may argue, is this directly or indirectly related to the norm that we know from the international humanitarian law, that is forcible transfers of population from and within the occupied territory are prohibited. But my view and arguments go as follows. Why on earth is this element at all provided in the international humanitarian law, and why is the transfer of population protected? Of course, one element may be of human rights protection, but in passportization, again, if we compare, if we do the parallel analysis, it is also a human right to choose nationality, right? Even if there is no guaranteed right to nationality, there is a right to choose nationality. So if the nationality is conferred, if I don't really have choice, even though Russia played a bit, they were showcasing as if there was a choice and people were even given some time, which was incredibly short, but still to make choices and so forth. But then all the administrative procedures were so difficult that, of course, this was just a illusory choice given. But again, if you look at this element of humanitarian law, which says you should not touch population, the core population of the occupied territory, what is it for? It is first for the human rights protection. The other one is from the state sovereignty and perspective, right? With that, if we now compare the passportization, what is it? If I don't have a choice to choose for passport or the other one, my rights seem to be violated. If my state loses citizens, and again, I agree that unless you have citizens of nationals, so it will be difficult at the end of the day to prove that actually that is your territory, right? So with that, I think that this is one linkage. And then if we get back, and I will finish very short, quickly. If we get back to the another prohibition, which is that the transfer of the civilian population of the occupying power into the occupied territory is also prohibited, regardless whether forcible or voluntary. Here again, I link this to the idea of passportization, and even if you have human beings remaining, you have different type of human beings from a state's legal perspective, and they are others. And then, of course, we have the other theory developed by Russia, which is protection of nationals abroad. Very interesting interpretation. I think people could have tens of dissertations on that, and that's where it is. So, in my view, there is a direct linkage, of course, and the usage shall be made of the IHL rules in the cases you mentioned, Saba. If that answers your question.
Yes, thank you, Professor Khutsishvili. And before posing the last question to Professor Peters, we still have to focus on the main, let's say, topic of today's presentation. So I will have one more question to you, Professor Khutsishvili, regarding the freedom of movement in and outside the breakaway regions. So assuming that this passportization actually changes the formal nationality, let's say, of the people living in there, how this would affect their freedom of movement to go inside or outside of those breakaway regions. And in this regard, if you could also please outline the policies and practice by Georgian government. I'm not sure about Ukrainian, but at least the information which we have from the Georgian government, how they're trying to either prevent this change of nationality or to facilitate their movements, at least like inside Georgia or outside of the occupied territories. So if you could please speak about that as well.
Yeah, thank you. Now, to also link to what we heard previously from Professor Peters, of course, people may find themselves in limbo for a variety of reasons. From some perspective, they may be considered as stateless at the end of the day, depending on the interpretations. But I understand that I need to concentrate on Ukraine and Georgia specific cases. So if we move that way, luckily, and as Professor Peters mentioned, the two countries try their best to keep their nationals. And that is done even in violation of their own domestic legislation. For Georgia, Georgia does not recognize any of the other documents which may be illegally conferred on the population, which genuinely belongs to the Georgian territory, occupied territory. And therefore, you may have people with 3 passports, so occupied, local, whatever, Abkhazian passport, plus Russian passport, plus Georgian passport. And if in other cases, if in my case, as I belong very much to Tbilisi population, and that's where I am, if it would be considered illegal, if Georgia government would start procedure, at least, or consider administrative proceedings to actually tell me that I don't deserve my Georgian passport anymore, this is not happening in respect of population in the occupied territory. So you may have Georgian population in the occupied territories with 3 passports. My understanding is that Ukraine is trying to do the same. The Russian illegal passportization does not provide for legal basis for Ukraine to start their administrative proceedings. But here I also, again, have two elements to still address. One is to what degree the human rights may be violated, or the freedom of movement may be hampered. And the other case is what other domestic practices may be to overcome this. Now, of course, human rights may be violated, and this may be both formal and informal. Formal, again, I think we touched upon briefly already, and I would not revert to, like, formal check of document. But then informal is also linked to the absence of proper administration and rules. So if I take Georgian occupied territories and resident of occupied Gali region trying to cross into Georgia proper, what is it? What is to be crossed? And with what document? Right? And of course, there is a big probability that whatever document the person has will not be acknowledged by so-called border posts on the other side of the river, right? So what is that? It is informal hampering of freedom of movement. Would it be for medical? Would it be for educational, or so forth? When we talk about people staying in limbo and becoming basically passportless, I would call them this way more than stateless, there is, of course, limitation on any kind of travel outside whatever locality they are in, which of course also hampers the right, the access to right to education abroad, for example, or whatever. So on the Georgian practices, to quickly wrap this anyhow, as we when talking about passportization, we refer to state interests, human interests, including humanitarian interests. Georgia came up with the solution to invent a so-called status-neutral travel document, which would basically integrate all the components that I listed here and there. That Georgia would say, for the humanitarian purposes, to make sure that people do not have obstacles when moving. There is no limitation on freedom of movement, but also that my sovereignty is duly respected. I have this. So it is a document which, well, we know that with the code GE means that people will know that this document is issued by Georgia, but there is no coat of arms of Georgia. There is no mention of the word full war Georgia in the document. It's just a document which shows that the owner of this document is protected by a state called Georgia, which means that probably there is a genuine link of a person with the country called Georgia. So I think I should stop here unless I missed any points.
Thank you very much. Yeah, the status neutral document was very important, and it's good that you mentioned that how this could facilitate the freedom of movement by people who are living in these breakaway regions if they want to go in European Union, for example, or any countries which recognize this status neutral documents. Thank you, Professor Khutsishvili. And for the final question, before we open the floor for the discussions, I would like to kind of finalize and ask Professor Peters to speak about the legal consequences of these passportization practices. If proved to be unlawful, would other states be under an obligation not to recognize new citizenships of for those persons who acquired nationalities through this passportization practices? Please, Professor Peters, you have the floor.
Yeah. As you already said, and as I said at the beginning, so the one thing is that Russia confers the nationality, and the other question is then how must other third states react? And the convention, the European Convention on Nationality, which I mentioned, which is ratified by Ukraine but not by Georgia, says in its Article 3, it exactly mentions the two levels. Namely, it says first, each state shall determine under its own law who are its nationals. But then, Section 2, this law shall be accepted by other states insofar as it is consistent with applicable international law and the principles of law generally recognized with regard to nationality. So this means that other states must not, or they are not obliged to recognize the nationality. And the core factor for the other state's decision whether to recognize this purported nationality or whether to qualify the nationality as exorbitant or excessive and not recognize it is the question of the effective link again. There is also, interestingly, case law by the European Court of Justice or by the Court of the European Union on that. There have been several high-profile cases which did not relate to passportization, but which related to the recognition of nationality. And then this involves also the European Court because the nationality of a member state confers the European citizenship. And therefore, sometimes the European Court of Justice has been asked on these issues. And there is even a recent decision where the European Court of Justice says that it must not necessarily be recognized by other states. And then one could even argue that the states can invoke their ordre public to say that it is my ordre public not to recognize this exorbitant nationality if there is no factual connection to Russia. However, normally the states and the courts of the states are very reluctant. So normally the nationality will be accepted only if there are serious doubts about the legality. However, I think that in the state of the Russian passportization, there are indeed serious doubts, and one could maybe even argue that a state should not or must not recognize an excessive nationality because this will cement and perpetuate the breach. For example, the International Court of Justice in the Wall opinion on Israeli wall said that if there are important rights and obligations involved, the court is of the view that other states are under an obligation not to recognize the illegal situation. And I think this does not only relate to breaches of peremptory norms, but important norms. So if we extend that opinion, we could say that states must not recognize such a blatantly unlawful conferral of nationality. And this is also confirmed by the International Law Commission's articles on state responsibility, which says that states are under an obligation not to recognize as lawful situations created by a serious breach of peremptory norms. Again, if the, as I mentioned, the European Union's Council has in the Council conclusions of June 2019, after the beginning of the Russian simplified procedure to grant the nationality for the inhabitants of the Eastern Ukraine, the European Council conclusion says that the EU is ready to consider further options, including non-recognition of Russian passports issued in contradiction to the Minsk agreements. And there is also a EU guidance on the handling of visa applications from residents of Ukraine's Donetsk and Luhansk regions, but this EU Commission guidance is not public, so I only found a press statement on that guidance, but it is a non-public document, so I don't know exactly the criteria. But the European Union Council envisaged non-recognition. But of course, as Professor Khutsishvili said, for humanitarian reasons, this will the policy must, of course, make a priority of the needs of the population, not to make the situation of the population worse.
Thank you. Thank you very much. Thank you for both the speakers about this outline and speaking about the main points of the passportization policies and practices. And now we open the floor for the discussion. And as I mentioned in the beginning, I will repeat it once. So the attendants can pose their questions either by raising hands, and I will allow them to talk. So you will be then promoted on the screen, and you can unmute your mic and ask the question. Or there is also an option to put the question in the chat. Or there is even a question and answer button on the below case of your screen, so you can take either of these options to use it. And we have a first question from Tinatin Oboladze. I will read it out because it's in the chat, and then maybe we can decide who will answer that. Professors, in the Georgian context, we have a legally qualified state of occupation along with ongoing passportization starting as early as 1999. Additionally, Russia officially proclaims Abkhazia and South Ossetia as independent nations, in contrast to the Ukrainian situation. Okay, how should states differentiate between the end of occupation and transitioning to de facto annexation by means of passportization policy? What could be used as proper theoretical criteria? So as I understood, the Tinatin is referring whether the passportization already could be the like a benchmark where we could say that the occupation basically ends and it's already de facto annexation. If I'm not mistaken, that's I think what the main idea of the question. So I think this is directed to both of the, because she said that professors in the beginning. So either of you can start. I don't know.
Well, maybe of course, Professor Khutsishvili is the specialist in international humanitarian law. I think that this is a very innovative question, so there are certainly no established criteria, but you're asking for theoretical criteria. So what would be sensible criteria? Well, as you know, occupation is defined in international humanitarian law by the Hague regulations and by customary law as a purely factual situation, that if a territory is in the power of a foreign army, factually. So what's the difference to an outright annexation? I think in the case of an annexation, the state formally also says that this territory is now part of my country. As, for example, Russia says with regard to Crimea, Russia argued that the people of Crimea had exercised its self-determination with help of the referendum, and that it was then for one day or so an independent state, which then concluded a treaty with Russia in which it asked to be incorporated into Russia. That was, I think, the sequence of events in 2014. And the result is that Russia openly and formally says this is Russian Federation now, and this was an annexation. Whereas with occupation, the state doesn't claim that, but maybe Professor Khutsishvili could help on that point, and then we can try to think more on the criteria.
Yes, I'll try briefly. Well, annexation is in fact the acquisition of title, right? So the state basically acquires the, well, we could say ownership over a territory, and it is not what I mentioned with the occupation. It is not temporary, because annexation is at my part. Now, I would say it's not very directly linked. If we only take passportization into account, if we say that now we have, I don't know, 100% passportization, therefore we now qualify a situation as an annexation, I think that would be stretching too much the edges. However, again, if the acquisition of title over the territory may be proven also with support of the passportization, and then that's a matter of separate discussion. But I would find it difficult to only link the two and then suggest that there are this and this criteria to establish the fact.
But can maybe to add on that, I agree, but purely a kind of a little bit formal argumentation would be, of course, that if 100% of the population is now Russian, then it is a parallel to the territory. Then it is a annexation through the persons as opposed to an annexation of the territory. But that is maybe a bit too formalistic. So I think that, as Professor Khutsishvili said, that if you use the passportization in addition to fortify also the presence on the territory, then there is a combination of the element of the state's population plus the state's territory, and then this is closer to full incorporation into the other state.
Thank you. Thank you, and thanks also to Tinati, who is ours. I mean, who was our student. She was already graduated, but she was very active student. We have another question from
who is already teaching others, by the way.
And teaching already others, yes. So we have another question from Onisimets Homelidze, who is also another colleague of ours, a PhD candidate, and also he works in the International Committee of the Red Cross. And Onisime, I promoted you as a speaker, so you can pose your question, please.
And he is also on the roster of ICC Defense Council. So.
Thank you, Saba. Thanks for, first of all, for choosing this topic, which is quite interesting. And thanks both speakers for this interesting comments and presentations. Actually, I have both a question and a comment. My first comment is related to the previous question regarding the difference between annexation and occupation, and how it can, and in theory, if it can be done through passportization. What I would like to emphasize here is that I don't want to refer to particular context, Georgian or Ukrainian. It's a hypothetical question and comment also. What if we look at this issue from a different angle to say that if passportization might be used as a leverage by a state to avoid its obligations under Geneva Convention 4 as an occupying power, and especially if we are speaking about widespread passportization, that means that obligations stemming from Geneva Convention number 4 are obligations towards those people who find themselves in the occupied territory, but who are not nationals of the occupying power. And this issue might be used as a method to avoid its particular obligations. That is the comment, the part regarding the comment. And second one, I would like to listen to both speakers regarding their position, how coercive environment can be as a trigger for passportization, how genuine will of a person to apply is established, and in a long-term perspective, for example, in terms of access to social assistance or access to healthcare, these problems might not be linked to individuals, but the environment might be either intentionally or due to other underlying circumstances might be created, and this environment might affect formation of the will of a person to apply individually. Thank you in advance.
Thank you, Onesime. And this is very interesting. I never thought about this, like that this policy could be used as a means to prevent obligations under Geneva Convention. This is a very interesting observation, and thank you for this comment. And as for the questions, I think we briefly spoke about, but if you can if we want to expand on that and elaborate more on that, maybe we can start, Professor Peters, maybe from you, and then Professor Khutsishvili.
Okay, thanks a lot, Onesime. As you say, the Geneva Convention, Fourth Geneva Convention, protects persons, the inhabitants of occupied territories, and according to the wording, the Geneva Convention 4 says that these inhabitants are not nationals of the occupying power. However, I think I remember that the Yugoslavia Tribunal has issued a case saying that in a civil war, which was in that case in Yugoslavia, the criterion that the protected persons are not nationals of the occupying powers can somehow be overcome, that they are also protected if they are de facto stripped from protection, if they are not protected, even if they are the nationals of the occupying state itself in the civil war. And therefore, I forgot the name of that case. If you take that case, then this means that the occupying power cannot evade its responsibility simply by transforming the inhabitants into its own nationals. That's my remark on your first point. I don't know, Professor Khutsishvili, do you want to come in or on that point?
Very, very briefly, and then we continue with the second point. Maybe just very briefly, I would still argue if that scenario was developed to reach any of the judicial forum, I would argue that the genuine link and then the genuinity behind the process is at stake, and therefore the result is null and void. Therefore, there is no national of occupying power, and these are still people under occupation that need to be protected under Geneva Convention 4.
Okay, now coming to your second point, what is the threshold where we must say that the will of the people who apply for the passports is no longer free exercise of will? I said that when there is an overall military context and when it's really at the gunpoint, when you see or when the population sees the tanks and that there is a militarization of the situation, then with regard to referendums, the law is quite clear. The soft law, the Venice Commission, for example, says that then there is no free will. I'm not aware of any we could draw maybe on the norms on Article 25 of the ICCPR, the Covenant on Civil and Political Rights, which guarantees everyone the right to participate in free and fair elections. You know that this is a human right. So maybe there is case law on that human right to identify situations where we no longer can speak of free elections, but I don't know whether that's the case. And generally, I don't see any other provisions in human rights law which would fit. And otherwise, of course, we have the issue of coercion of a state representative when concluding a treaty, for example, under the Vienna Convention of International Law. There is this prohibition of coercion, but there is also no dense case law on that to identify when the threshold to coercion is crossed. It's a very nice question, of course.
Maybe also briefly to come in here, Maybe from practice, what's developed, and again, we can refer to the same Ukraine. Again, as it was outlined, passportization per se is not always illegal, right? You may have this happening, but what is to be considered is, I'm not sure about the exact threshold, but the factors are pace, the compatibility with the territorial state's legislation, context, also the scale, on what scale this happens, and presumably also the degree of injury to the territorial state as a result. Now, as we spoke about Ukraine, just one example again, when the Russian Federation issued its legislation to start basically passportization, people were told that they have rights, so they have a choice, so they could have opted, but then all the practical obstacles started, which already meant that it was a refusal. It was not a real choice, but it was just a sham suggestion that would not lead anywhere. There was a very short time period given to the people to decide, to make up their minds. And as Professor Peters mentioned, when you have ongoing armed activities and you are given a passport which maybe gives you a ticket to Moscow instead of staying in your ruined town, well, probably you start thinking about taking it, and then we can argue, can this be a contextual element for basically conferring the nationality? Probably, again, if the court discusses this, maybe there are elements to come to this conclusion. Then, in Crimea particularly, people without Russian passport would not exist as human beings anymore. So you wouldn't be able to have access to a number of issues. Is that degree enough for compulsion? Probably yes, right? So therefore, you may have a formal choice, which was the case in the case of Russia dealing with Ukrainians' passportization. But then again, we see that it was not a real choice. And maybe if these elements are put before the court, we may have a court practice telling us what exactly this threshold may be in such cases.
Thank you. Thank you, Onisime, for your question, and thanks, professors, for your replies. We have, I think, one question from the chat and one who wants to talk, and I will first allow Georgian Agashidze, also a colleague of ours, the PhD candidate and the charge d'affaires of Georgia in the Kingdom of Netherlands, and I think also he is accredited representative of Georgia in the Assembly of State Parties of the Rome Statute. So, Georgi, thanks for joining us, and you have the floor, please.
Thank you, Saba. Good evening, distinguished panelists, professors. It's an honor to listen to your views and answers to these very important questions, personally for me and I think for all of the audience. So today's topic is focused on the movement of those people living in breakaway regions and who are subject to passportization. However, my question will be broader in terms of so well-known criterion of genuine link. So today the concept of nationality under international law, not necessarily under domestic law, revolves around so genuine link. I wonder, so we know the genuine link is a kind of invention by ICJ in its well-known notable case, which was like 60 years ago. So in today's complex development of international law, and it was 60 years ago, I would like to listen your views. Is it still relevant to focus on genuine link, or we need another kind of functional approach? Because, for example, as Saba mentioned, I am really closely follow the ICC and ASP in The Hague, and it went unnoticed for many commentators that in 2019, the prosecutor had a case where it's first time had to decide over dual nationality issues. It was North Koreans and South Koreans kind of not preliminary examination, but kind of preliminary examination. And the prosecutor of the ICC said that despite the fact that South Korea domestic law confers nationality to North Koreans, and the prosecutor could exercise jurisdiction over North Koreans as South Koreans under South Korean law. This was not sufficient for jurisdiction, as such North Koreans could not exercise their rights in Korea under permitted by separate applications. So the prosecutor did not rely on genuine link as such, as we know the basic concept by ICJ. So just your views, is the genuine link still relevant, or we need another approach to decide dual nationality issues under IHL, under freedom of movement, and so on? So, thank you.
Thank you, Georgi. Thanks. Very interesting indeed questions. So maybe we could go again, Professor Peters and Professor Khutsishvili then.
Are you sure I should start? Okay, I can start. It's okay. It's okay for me. Yeah. But I think that this is Georgie, thank you for that remark. I think this is, of course, very, very important that nowadays, in times of globalization and migration and dual nationality, the traditional view that nationality constitutes a very tight bond between one state and a person and must also be exclusive, that this is somewhat outdated in our times. There are even people who argue that there must be a human right to dual nationality. And of course, it's very important that migrants can fairly quickly and easily obtain nationality. So I think that this whole trend, which you mentioned, clearly points towards a much more relaxed link between one state and persons who are, we are all global citizens in a way. But on the other hand, there is now also the tendency, as I said, from the side of states to try to attract nationals purely through money, like the golden passports by Cyprus and Malta and so on. Actually, that goes in the same direction, which says that it must not be a genuine emotional, traditional or cultural link, but that it can be bought, full stop. Yeah. So it's really also a commercialization of nationality from the side of states. So this would also go into your direction. And the third point is, you know, all these kinship policies, for example, that Hungary and also I think maybe Turkey, that also tries to expand its nationality on ethnic Magyars. So this is not only a way of making money, but also a tool of identity politics, strategic like the Russian one. So this also, I mean, as a matter of fact, we have to take note of that. So even if this is a trend which we maybe find not so positive as this cosmopolitan trend, it still is a fact that also from this perspective, nationality seems to have changed the character of nationality. On the other hand, the European Convention on Nationality of 1997 still mentions the word genuine link. In Article 7, the convention says that a state may not provide for an ex lege loss of nationality except for lack of genuine link between the state party and a national habitually residing abroad. So the convention still mentions the word, which was coined in Nottebohm, and it also applies it, and it applies it specifically to the extraterritorial nationals. And there is a recent judgment by the European Union Court, the Tiebes case, which was decided by the Grand Chamber in 2019, which was also on the loss of nationality for extraterritorial nationals. It was a question of reference, and the court was asked, because the loss of nationality implied then also the loss of European citizenship. And the court said that it is legitimate for member states to take the view that nationality is the expression of a genuine link between it and its nationals. And the European Union Court also in other cases constantly says, well, nationality is a solid relation based on solidarity and good faith. So that is a buzzword the European Union Court uses, solidarity and good faith. And you can say, well, that also sounds a bit outdated. That has also been criticized, but this is still the EU case law.
As we are nearing the end of our conversation, I will very briefly come in. Actually, I like the idea, and I will support this from another perspective, which is extradition. There, you don't have any general. If you have a person to be extradited, and you have concurring requests, there is no link to nationality. So it is a choice of a country making extradition that goes in the Council of Europe framework, but also elsewhere. So I cite this example because I support the attitude, particularly when it comes to fighting a crime, and particularly serious crime. Maybe there is need to reorder things that we have been using and we are used to, and has become, I don't know, conventional knowledge almost. So I would like the idea of changing, but carefully, because I also see the risks related to the state sovereignty. If it is done, you know, you always have good inventors and states to try to interpret principles and processes so that then you have other violations. But so to cut it short, I support the idea, but I still think that, like with democracy, this is not the perfect one, but we have what we have. So that's how it goes.
Thank you. Thank you, Georgi, for your intervention, and thanks, speakers, for the answer. And I think for the final question, we have one left in the chat, which speaks about the larger issue, I would say, about the influence in the Black Sea, because we know that two of these breakaway regions, Crimea and Abkhazia, are borders with the Black Sea. And the participant Levan, he asked whether this passportization could be also kind of cover up to influence, to increase the larger influence on the Black Sea. And we have already witnessed, I think 2 weeks ago or the week ago, when the British shipment was coming through the Black Sea, because the Britain does not recognize the Russian sovereignty over Crimea. They did not formally send the notice to Russia, and there was kind of exchange of there was tension, I would say, because the information was not like very clear whether there was kind of exchange of something, but like was tension in that. So what would have, I mean, what kind of this passportization, what kind of impact it could have about the maritime security in the Black Sea? Well, this is really a very broad question, but just your maybe ideas about that.
Yeah, first of all, I still want to insist on the difference between annexation, which is, as Professor Khutsishvili said, permanent, but of course is not recognized as conferring a valid and good title nowadays in international law. It's illegal, but nevertheless, the state formally says Crimea is part of Russia, whereas South Ossetia has been recognized by Russia as an independent state. I think Nicaragua also recognized South Ossetia, but that's about it. Okay, so Russia claims that this is a different state, but as you say, the strategy of bringing the region under Russian influence is of course similar, and you could say that this is now a kind of informal empire or a neo-colonial move to recreate a kind of Soviet sphere or a post-Soviet sphere of influence, so that maybe, as you say, considered from a point of view of strategy, the difference between the formal annexation and the recognition as a pseudo puppet state is in reality, in political terms, not important.
Yes. Professor,
I would just add very briefly that if you look at the geopolitical movements and the different active involvement of the countries within the region, Turkey, not to forget about, I would see potential truth behind this, and of course, if this can be attained by this means, which is probably easier than all the other means that Russia has been employing in the region recently. Why not? And at the end of the day, as perceived by Russia, it's backyard. So why not to make sure that the backyard stays?
Thank you. Thank you very much. I think as long as we don't have any questions, and I think our time is already expiring, I would like to sum up today's discussion. Thanks to all the participants and all the speakers. It was indeed really like a huge privilege and honor to me personally to be moderator here, and I really enjoyed for the very interesting presentation and the questions as well. And maybe like if you for the speakers, if you want like just the concluding remarks of your impressions of today's event, just briefly before closing the event.
First of all, it was my pleasure to participate, and of course we must be careful not to overestimate also the guidelines which international law can give us in this situation. As I said, the passportization is probably not illegal. At best, you can qualify it as an abuse of law, which is also somehow a little bit of a kind of a softer category or blurry category at least. However, I think we should still try to exploit the legal arguments which we have to make some points, recognizing that maybe other factors of order in international relations will be more powerful than the legal factor, for example, economic pressure or brutal military violence.
And Professor Khutsishvili?
Sorry, my mouse is, or whatever this is running away all the time, so I have to catch it. Not only this last statement, but Professor Peters mentioned in the speech also that maybe Russia needs to attract people economically, like when Saba mentioned pensions and so forth. And that was something that, I thought, well, if I was talking about something else, I would elaborate on that. And now maybe just to finish with this. I agree that probably the best way to reintegrate, because that's the problem, right? Reintegration, and then all this is done not to allow reintegration, is to bring people back by means of people-to-people contacts, which may also mean economic opportunities, not only, but also, and it is important, we know people migrate, it was also mentioned. Why? Because they seek economic better life, not the rich life, but better life where people may survive. That is why I think that the best way to support, but this is still to be invented because we have not seen any good ways of using these tactics of reintegration, would be people-to-people contact, which of course also shall be attended by the economic opportunities and social guarantees probably.
Thank you. I think this was a real culmination of today's events. I know the Levan Alexidze Foundation had a lot of events today, online events, although a good culmination of this important day, International Law Day, which coincides the birthday of our beloved Professor Levan Alexidze, and it's all the second year we're celebrating this. And this was indeed a good, let's say, occasion for that. And I'm particularly happy that we had Professor Anne Peters with us. And thank you once again, Professor Peters, for your time, for your dedication, and for your efforts to joining our today's session. And we hope that we will have other opportunities to have you with us in the future as well. Thank you, Professor Khutsishvili, also for your contribution and for all your efforts you are doing to promote the legacy of our beloved Levan Alexidze, founder of the International Law School in Georgia. Thanks all the participants, and with this I think we can conclude our today's event, and you may be disconnected from the event. Thank you, goodbye, have a nice evening.
Thank you and goodbye.